So, in the last two episodes of Lex Prudence podcast, Automotive Industry Series, we analyzed several suggestions made by FADA on the model dealership agreement and my views around the same. Uh, that brings us to another interesting area for legal professionals within the automotive industry, and that is product warranties. Hi, friends. My name is Amol Apte, and you are listening to me on the Lex Prudence podcast, Automotive Industry Series. If you haven't had the chance to listen to the previous episodes of this podcast, then please do so. Also, if you are listening to the episodes regularly but haven't for some reason subscribed to the channel, then please do so. It will give you alerts every time I release a new episode and will also make life simpler for you to search old podcast episodes for this channel. Okay, so now that we are through with routine formalities, let's just straight away jump into the subject that we have today, which is product warranties. I still remember 20 years back when I was part of the OEMs and was working on a project to revamp warranty terms and conditions with my then boss and the service head in the room. The service head at one point said, "Let these smaller items be. They are just tinny mini expenses. Uh, and why do you want to disturb them?" And the answer that my boss, who also used to be the head of finance, gave was that your tinny mini expenses become 5 crore a month for the company, and you don't even realize it. And I'm talking about a time about 18, 19 years back. So it's evident that the warranties are a large part of expenses for the OEMs and need a very careful evaluation drafting by the legal teams. Now, what do we mean by warranties? Or what is this concept of warranties, and how and which statute actually deals with the concept of warranties? So, in India, the concept of warranties is dealt by the Sale of Goods Act under Section 12(3). The Act says, and I'll read or rather quote unquote, a warranty is a stipulation collateral to the main purpose of the contract. That's first part. It's a stipulation which is collateral to the purpose of the contract, the breach of which gives rise to a claim for damages, but not to a right to reject the goods and treat the contract as repudiated. So it has about three parts to it. The first thing that it says is it is something which is not the main contract but runs parallel to or collateral to the purpose of the contract. That's first part. The second part, it says that if there is a breach of a warranty, then what you can do is to claim damages, but you don't get a right to reject the goods or treat the contract as null and void or repudiated. So that's Sale of Goods Act, Section 12(3) for you. Now, in the OEM world, the product warranties can be simply put as commitments made by the OEMs about certain parts in the equipment or vehicle to protect the end user from incurring certain unplanned costs in case the covered parts fail prematurely. So, for example, I buy a car and there is a product warranty for 5 years given on several parts of the car, and my steering fails for some reason which is not within my control, then warranty should ideally cover that failure of the part. So, under the warranty, if a part in your vehicle fails before the committed time, the OEM takes the responsibility to restore the vehicle to the original position. It works similar to uh, an insurance for you, where uh, an OEM is trying to bring you back to the original position as if no damage was caused. Now we need to pay attention here, since it's a warranty and not a condition under the Sale of Goods Act. The commitment here is to make good the damages and not to replace the entire vehicle or product. So if a steering has failed, all you may get is replacement for those specific parts free of cost, which have led to the failure of the steering and not changing the entire car. Now, for a legal resource, the language and careful attention to detail while drafting a warranty policy is of extreme importance. And let's see why. What are all the things that a warranty document should ideally cover, or what are all the things that a warranty document usually covers? Let's have a look at it point by point. The first and foremost, and mind you, this is just a suggestive list of things. It's not an exhaustive list. So don't think that it is a complete list and there's nothing beyond this that can come in the warranty policy. I'm just putting up a suggestive list of things. The first thing is, what is the tenure for which warranty is given? That's the first part. The second part, and I'll discuss these in detail also. The second part is, how is the warranty period connected with the services and the service schedules for the product? So what is the connection that I'm drawing in my warranty document, where I'm putting certain obligations on the user to bring the vehicle to service stations to service it on a regular basis? How is it dealt in the policy document? The third thing is, what is the time from which such warranty should start, and from where does the period needs to be counted? That has to be elaborately clear in the warranty document. The fourth point is, what are all the conditions that need to be mandatorily followed by the user to make sure that he or she continues to enjoy the benefits of warranty? So I'm not giving an unconditional warranty, right? I'm what an OEM will do is put certain conditions. If they are followed in letter and spirit, then I assure you that the product should behave and work and serve you in a particular manner. And if it doesn't, I will make good the damages. The fifth point is, are there some parts which need to be kept outside of the product warranty because they are what we popularly call as consumables, and are such that they are prone to wear and tear on a routine use as well. So these are 4 or 5 things which are very important for us to keep in mind while we as legal professionals are drafting the warranty documents for a product. Now let's go one by one and try and unpack these 4 or 5 points that I talked about. The first one was, what is the tenure for which warranty is given? You would have seen, all of you use vehicles, you would have seen typically the tenure ranges from 2 to 5 years, depending on what sort of product you are buying in the market, what sort of OEM is selling you that product, and OEMs have their own policies around it. So it ranges from 2 to 5 years. In some cases, it goes well beyond 5 years also. In some cases, it may be somewhere in between that. But one important point is, in most cases, it is a combination of two things: a fixed distance traveled or covered by the product over a period of time, or a tenure, and whichever is earlier. So say, for example, if my car has a warranty of 2 lakh kilometers or 5 years, whichever is earlier, then if I have a daily run which is say 100 200 kilometers, then my warranty may lapse before somebody who actually uses the vehicle only occasionally, and his number of kilometers per day is like 4 or 5 kilometers only. So that becomes very, very critical as to what is the tenure for which the warranty will be valid. The second thing is, how is the warranty period connected with the service schedules for the product? Now, as I said, the OEM also wants to put certain obligations on the user of the product, and therefore it is usually connected with the service schedules prescribed for the product. The warranty is also connected with timely and regular service of the vehicle, so that there are two things that an OEM can achieve. A, it allows the consumables, as we discussed just now briefly, and we'll discuss it again, the consumables are replaced and other parts are serviced from time to time, so that it's ensured that they run their life as prescribed in the document. The second thing is, since the warranty is conditional upon services done by the authorized service stations of the OEMs, it allows an opportunity to the OEM to have track record of the vehicle in their possession. So you actually know which date the vehicle came in, what sort of problems it reported, what sort of services it underwent, what sort of changes it needed in terms of consumables, was there any accident? all that information is readily available at your service station. So it gives you two opportunities when you connect your warranty with the service schedules of the product. A, you get to service the product to your satisfaction uh, as an OEM, and two, you keep a watch and keep track of the vehicle and keep it under your supervision so that you know if there is any chance of failure. The third point is, what is the time from which the warranty will start? Typically, you would want to count the period for which warranty is valid from the date on which product is registered in the name of the customer and the possession is given to him or her. So that's when the warranty should start, and from there you will compute your 2 years or 5 years or whatever period for which you are giving the product warranty to a user. You should start counting it from that date. The fourth point, which I spoke about, was what are all the conditions that need to be mandatorily followed by the user to make sure that he or she continues to enjoy the benefits of warranty. All of us know that warranty is never unconditional. So there will always be conditions like a list of parts that are covered and list of parts that are not covered, or rather list of parts which are specifically excluded from the warranty. Then there will be conditions around service of the vehicle, use of certain specified parts, oils, fluids, etc., etc., which is prescribed list of things that you need to take care of. Third is conditions around damages caused by consumer use, accidents, events and things within user control, etc. So, for example, some electrical fittings done outside of vehicle specification and from an unauthorized center causing some electrical damages in the vehicle may lapse your warranty. So that's an example of things that a user shouldn't do, or things which are well within the control of a user and yet a damage is caused to the vehicle. Probably you would want a specific language around this to exclude these things from your warranties. The fourth thing is, what all will the OEM cover under warranty and specifications around it, such as exclusion of labor costs, parking costs, and other variable costs, which are like other than the actual cost of the parts itself. That has to come in very clearly in the warranty. So if a vehicle comes for you uh, or at your dealership for a service and there are parts to be replaced under warranty, while you may not want to charge for the parts price, but the other things, which is replacement cost, etc., is something that you will charge. And therefore, the warranty document has to be very, very clearly spelled out in terms of when it comes to the costs, what kind of costs are covered under your warranty and what are the costs which are not covered under the warranty. And last but not the least, as I said, it is just a suggestive list that I'm discussing here. Are there some parts which need to be kept outside specifically because they are consumables? So again, all of us know that not all parts are covered by the product warranty. There are a few called as consumables, and those parts are such parts which are prone to wear and tear even with the normal usage. So say for example, filters, the rubber parts, some certain accessories which are outside of the original vehicle, etc., etc. So these kind of things are kept specifically outside of warranty, and therefore it becomes very, very necessary or very, very important for you as a legal resource to cover them up categorically in the warranty document as something which is not covered. So we can see as to how many things and angles one needs to keep in mind while drafting a warranty policy for the product. One needs to be really careful in the language of the drafts, as well as one needs to take various views and practical scenarios from the sales, your services guys, your product teams, as well as keep the capacities, commercial arrangements that the OEM has with its ancillaries in terms of supply of spare parts, etc., dealers' capacity to service the products, etc., also in mind when you are drafting the warranty policy. You wouldn't want to go overboard in terms of committing certain things which your dealers with whom you have a commercial relationship won't be able to, or your service stations won't be able to provide to its end user. and that will only result in damages claims coming to you. So you have to be very careful. Take feedbacks from sales, take feedback from service guys, take feedbacks from product teams because they know their product better. Take feedbacks from the people who are dealing with your ancillary industries who actually supply those spare parts to you, and their capacities, whether they'll be able to certain parts which are very prone to wear and tear and are covered under warranties, and the capacity of your ancillary is limited, then you may want to create language which enables that much more time for your dealer or a service station to replace those parts. And those kind of considerations is something that you have to be, as a legal resource, be very, very careful about. Now, the question arises as to what are the rights of a buyer or the consumer when there is a breach of warranty by an OEM. Again, we go back to the Sale of Goods Act. The Section 59 of the Act provides the remedies uh, uh, in case of breach of warranty. So let me simply read the provision of Section 59, and then we will try and break it down to understand the remedies better. Now, what is the remedy under Section 59? It says where there is a breach of warranty by the seller or where the buyer elects or is compelled to treat any breach of a condition on the part of the seller as a breach of warranty, the buyer is not by reason only of such breach of warranty entitled to reject the goods, but he may set up against the seller the breach of warranty in diminution or extension of the price. That's the first part. Or B, sue the seller for damages for breach of warranty. And the second subsection says the fact that buyer has set up a breach of warranty in diminution or extinction of the price does not prevent him from suing for the same breach of warranty if he suffered further damages. Now that's a literal thing. From the bare reading of this section, we can see that you as a buyer or your buyer can either reject the goods or claim reduction or refund in price recovered from him or bring a suit for damages. These are the remedies that are available to him. If the defects are so apparent in nature, he may reject the taking the possession of the vehicle itself, or he may seek certain discounts from you, or he may also seek damages from you. These are the remedies available. Also, merely because your user has sought reduction in price or refund price or whatever it means, it doesn't mean that he has lost the right to bring about the suit for damages also. The section clearly says that reduction or refund won't result in the right to sue for damages going away. So he still has that right to sue for damages. I'm not getting into the details of procedures to be followed at courts and forums where these remedies can be sought, etc., etc. But all of these are civil in nature, and therefore one can bring about a suit in an in a civil court of appropriate jurisdiction based on pecuniary and territorial jurisdiction, or even consumer forums under Consumer Protection Act can adjudicate upon these complaints of warranty breaches. Again, consumer protection also the forum under Consumer Protection Act also have their territorial and pecuniary jurisdictions prescribed. I'm not getting into all those details, but it will lie in a forum which has territorial as well as the pecuniary jurisdiction to adjudicate upon the subject. Okay, so we have come to an end of this episode of Lex Prudence podcast automotive industry series, and I hope you liked the discussion in today's episode and would love to hear your comments. If you like the content that I'm creating for this podcast, do let me know. You may also write into me to suggest the legal subjects that you would like to listen, and I will try my level best to bring those to you. So we'll catch up next week with a new episode on Lex Prudence podcast. Till then, namaskar.